on now. Give it to him. I'm back. I'm back. I'm back. Give it to him. It's time to get up off of that thing. Papa's got a brand new bag. I feel good. At least I'm trying to. Hello, kids. Hello, Ted. I feel good. I knew that I would. God has been so good, and his mercy endureth forevermore. It is surely a blessing, a privilege, and an honor to be before you once more and once again. As I take my seat behind this desk and revel in the opportunity once more to communicate to you, extol, expostulate, and whatever big word you might want to use to say, clarify these rules of evidence. It is at this juncture that I wish to thank you and thank God for just one more day. I am forever grateful for this chance. I don't take it lightly, and I'm excited to talk about these here rules. You gotta know the rules. And some of y'all was wondering, you were saying, oh, we got a video already for the Thanksgiving weekend. Well, guess what? In the words of James Brown, I'm back. And I'm going to give you another one. Lift your hands and get ready to receive it. God is so good. Truly, the Lord is blessing us right here and right now. So without further ado, let's get right into it. Because there ain't nothing to it but to do it. Let's talk about these here rules. I'm going to talk about rule 602 and then the 700s. I'm praying that this one will be short because, frankly, I'm tired of talking. Yes, I really mean that. As incredible as that seems, I am indeed tired of talking. So let's get to it. Let's talk about rule 602. Now, what is rule 602, you might be asking? Well, peep this new technology. Watch this. Y'all not ready for this. Look at this. Look at this. Look at this. Give it a second. It takes a moment to load. While it's loading, I want to take this time to thank once again all of you for tuning in today. Bam! There it is. Won't he do it? Won't he will? Let us see. Yep, there it is. Let's enlarge so that you might see. You understand? Make it bigger. For some of y'all got the vision of a tiny mole high up on a hill. 602, as you can see quite clearly, is the rule that talks about the need for personal knowledge. And so, what do we mean by personal knowledge? Personal knowledge is a rather simple requirement that could be reduced down to this simple thesis. We talk about this phrase here that we have here at Richmond Mock Trial, courtesy of one Timothy D. Patterson, reliability guarantees. Now, we've talked about this ad nauseum. This was in the 401 video. If you don't got it by now, well, you'll never, ever, ever have it. Well, I shouldn't say that, but you ought to get to know it. Listen to me. If you go have it, go back to the 401 through 405 video. That's also on the YouTubes. You can look through my channel since some of y'all seem so keen on it. Well, essentially, a reliability guarantee is what we use to refer to the reasons or the rationale or the particular danger which the rule seeks to preclude from being considered, as it is improper evidence for some reason or for some particular reason, or so the reliability guarantee for 602, I guess, relies on one particular thesis, and that is if person A wishes to talk about pi, person A should know pi. And that's pretty straightforward, is it not? It should be. You can't just talk about things that you don't know, because then you're just talking. You know, there's a difference between talking and talking. And so, if you're talking about things you ain't got no business talking about, then you're just talking. And you ain't helping nobody when you do that. Okay? So 602, the reliability guarantee of the rule, that being the main danger which this rule seeks to preclude or exclude or keep out from undue consideration, is when people or if people try to talk about things they don't know about. Let's read the text of the rule together. Yes, I know you can't read, but bear with me. A witness may testify to a matter only if, notice that only if here, evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Here I'm going to highlight or underline sufficient to support a finding. That's the key sort of buzz phrase for this rule. It doesn't have to be indisputable. It doesn't have to be incontrovertible or irrefutable evidence that one might know. But rather, it just has to be simply enough evidence to support the belief or the finding that one knows. So it's a much lower evidentiary standard than that of a civil suit or a criminal charge or something of that sort. All you need to do is sufficient to support a finding, have evidence that's sufficient to support a finding, or what we would often call foundation. You hear that term a lot. I hope we understand what that means, because we throw it around a lot. Maybe we ought to take time to define it. I guess crudely spelled out, foundation is simply evidence to support an idea, argument, etc., etc. Maybe that term idea is a little uh, too loose. Uh, maybe that's too loose a usage of the term here. Instead of, let's just say, an assertion / argument. Yeah, my handwriting's bad. We all know this. But y'all keep watching these videos. I wonder why. Somebody said because I make you. That's also correct. Stick with me. Y'all listening? I hope so. Now, so in order for someone to testify about something, they have to know. They have to know what that thing is. If person A wishes to talk about pi, they have to know pi. The evidence that someone knows pi comes through proper foundation, that being evidence to support an assertion or an argument. In this case, it would be, i.e., that the person knows pi. Okay? Now, for my logic people, for my philosophers, shout out Lily, shout out Anna. Y'all listening? Y'all better be. Listen to me. Now, for my philosophers, you notice that I've circled only if. Okay? Let's see. I'm going to break up this clause here. Let's say this clause is clause A. And that clause here, after the only if, is clause B. Clause B. So the only if makes this first sentence a conditional. Now some of you all, your eyes are ready to glaze over, you're ready to click off, but don't do it. This might be helpful to you to get to my next major point. Now, the only if here introduces a conditional. And as you all will learn, if you decide to make that all important decision to take symbolic logic, you will soon learn that only if not only formulates a conditional, but does so in the following manner. The clause following the only if becomes the antecedent, or the first term of the conditional, and then the, let's see, make sure I do it right. No, I'm sorry. It's the other way. Y'all pray for me. So the only if makes the first term, or the first clause preceding the only if, the antecedent, and the latter clause the consequent. Now, these aren't just highfalutin words we use to sound smart. They have actual value. Watch this, because if the A is the antecedent, then it becomes the sufficient condition. If B is the consequent, or the consequent, then that becomes the necessary condition. Why am I breaking it down like this? This is unnecessary. We don't need a logic primer. Yeah, you do, because some of y'all got bad thinking. I still love you, but y'all don't think well. Okay, now listen. The B part here in this rule, if you'll see it, is if evidence is introduced to support a finding that the witness has personal knowledge of the matter. Okay? That's the necessary condition. A witness may testify to a matter. That's the sufficient condition. Ergo, if you think about it, B is necessary for A, and A is sufficient for B. That's why I formalized this into the formal language, because I hope that you all can now see it. That personal knowledge is a requirement. Amen? Y'all not talking back to me. Amen. Personal knowledge is a requirement. I'm going to say it one more time for the young bucks in the back. Personal knowledge is a requirement to testify to something. And if someone testifies to something, that means that they have a sufficient foundation, or evidence has been shown or introduced that lays sufficient foundation that the person testifying knows about it. Hence this sentence here. Again, this is just a reiteration and I guess a formalization, so to speak, of this axiom right here. That's all 602 is trying to say, is if a person A wishes to talk about pi, person A should know pi. If someone's talking about something, then they must know about it. But if someone doesn't know about the event, they can't talk about it. Okay? So their knowledge of the event itself is called personal knowledge. Now, oftentimes during drills, we talk about 3 objections that happen under 602. Look at your neighbor and say, he's flying through this one. Yeah, I'm flying through this one, y'all, because I'm trying to go to bed. I'm a little tired. So objections under 602. There are 3 of them. Y'all ready? You better be. So we already talked about personal knowledge. So if you lack personal knowledge, there's no way you can know about something. So whenever you object to personal knowledge, this is what I'll do. My handwriting is getting worse and worse. So I'll just say objections of this sort assert that the witness can't know and therefore can't testify to a matter. So when you object to lack of personal knowledge, you're saying straight out, person A doesn't know pi and therefore can't talk about it. That's slightly different than the second sort of objection that happens under this rule. Lack of foundation. Person may know, but the foundation hasn't been laid. Y'all see that? Amen. Talk back to me. It's quiet in this Presbyterian church. Amen. Now, a lack of foundation, all right, is an objection wherein you're tacitly asserting that the witness could know about it. Let's say person A does know pi. Let's say person A was at the grocery store to see the shoplifting take place, and person A is called to testify. And the first thing that person A says while on the stand is, Leo stole the cantaloupe. Okay? Now, an attorney might say, objection, lack of foundation. Why? Because while he's making that claim, and he may know the truth of that claim, he may be able to testify that Leo stole the cantaloupe. Foundation, what is foundation again? Evidence to support an argument or an assertion, i.e., that the person knows. I actually wrote out pi, and y'all didn't stop me. Come on, y'all. Y'all gotta say something to the preacher. Y'all can't just let me do stupid stuff like that so y'all can kiki and laugh about it later. Yeah, okay. I actually wrote out pi. Y'all need to pray for me. Y'all not praying. Anyway, if going back to our example, if the witness, Lord, testifies that, he saw Lily steal the cantaloupe, but enough foundation wasn't laid, i.e., evidence to support the assertion or the argument that Lily was there, then that might be an objection that comes up, that there's not sufficient foundation to support his being able to testify. Now, one more word about foundation, because again, you'll hear that word foundation in multiple contexts. Foundation in the context of 602, let me write it here, applies to whether or not somebody knows the matter they're testifying to. But you have to lay foundation in other instances, right? Let's take hearsay, for example, or a hearsay exception. If you want to use 8033, a rule that you better know by now because y'all should have listened to that hearsay lecture, right? Right. Good. So in the hearsay lecture where we talk about 8033, the then existing mental state, you have to lay foundation, right, to establish that the quote that you're trying to get in or the statement you're trying to get in falls within that exception. So you have to have evidence to support the underlying assertion or the underlying argument that the evidence fits within the penumbra. I'm so sorry, my conservative friends. You should have a negative visceral reaction whenever you hear that word for reasons that won't elude you if you're in my favorite professor's sarcasm intended con law class. But anyway, you have to be able to lay the foundation if you're invoking a hearsay exception that the quote fits within the penumbra of that exception. So you have to provide evidence to support that argument. Y'all see that? So that term foundation has wide applicability, right? It might be foundation under 404b2. You have to lay the foundation sometimes that the prior act supports the argument or the idea or the notion or the assertion that it is in fact that act evidence of a motive or an intent rather than just simply a propensity to act in accordance with a trait or evidence of a propensity to act in accordance to a trait. Okay, so foundation is a topic that comes up a lot. It's not just a 602 issue, but it often comes up through 602 because it's one of the objections here. But it can often be used in response to other objections when opposing counsel says they need to, let's say, lay more foundation to establish that a statement falls within a hearsay exception. Okay? Or they need to lay more foundation under 702, which is something that we'll talk about. Okay? So, foundation has wide applicability. But here, when we talk about foundation, we're talking about foundation as it applies in context to, sorry, I just wrote in context, to 602. Okay? Let's talk about the third one. This is everyone's favorite. Speculation. What is speculation? Now, people throw this out a lot on about almost every 602 issue, but technically it's different than lack of personal knowledge. Me saying that I saw Lee steal the cantaloupe when I wasn't there to see him steal it, that's not speculative. I just lack the personal knowledge. But a lot of times this gets conflated. But technically, speculation is just technically defined as, I don't know why I wrote quotes there. Sometimes I just be writing and I don't really know what I'm writing. Maybe that's why my handwriting is so bad. Lord have mercy. Lord, do it. Lord, do it. Okay. Let's see. Speculation is testifying to another's mindset. Okay? And that makes sense why that would be objectionable, right? Why? Because you don't have the personal knowledge. I'm going to write IE here. IE, no personal knowledge to speak to another person's thoughts. So it's just speculation is a very particularized lack of personal knowledge objection that pertains mainly to and only to the mindset of another person. You can't know what another person's thinking. You lack the personal knowledge. And so whatever opinion you have about what the other person was thinking, feeling, emotionally, physically, that's speculative. So you'll hear this a lot of times with, she felt, or her emotional state. She was angry, or, she believed. Okay? She thought. You can't know that stuff. Why? Because in the words of our friends at Seton Hall C, ask me for that story later in person, you're not a mind grabber. Okay? You're not a mind grabber. Okay? You don't know. You you ain't there. You don't have the personal knowledge. And so because you don't have the personal knowledge to someone's mindset, I can't say that enough. Because you don't have the personal knowledge of someone's mindset, that's speculative. Okay? Now I'm almost done with this rule. I gotta say one more thing, and then we go fly through these 700s because they're not that hard. Okay, just got to make a few distinctions, bring up some case law on one of them, and then 703 through 705 should be a breeze. Look at your neighbor, say breeze. The evening breeze caress the trees tenderly. Anyway, sorry. I don't know why I've been singing a lot lately. Then you and I came wandering by. Okay, so, word about 602. What was the last video about? Uh-oh. It's about chains. Chain, chain, chain. Y'all remember that? You ought to. So how chains often comes up under 602 in this way. Let's say I know Lily, that's Leo, also known as Leop, also known as Bimo. Let's say I know that he stole the cantaloupe only because my girl Anna told me that he stole the cantaloupe. Okay, so I have 602 foundation to say Leo stole the cantaloupe. But the foundation only exists through the truth of Anna's claim. Y'all with me? Look at your neighbor, say amen. Also known as hearsay. Okay? Just in case you're only following along by looking at the board for whatever reason, instead of listening to my beautiful voice, I'm going to write it up here. Lily's stealing cantaloupe. I can't spell. Cantaloupe. We're going to hope that's right. I only know about that through Anna's telling me that Lily stole the cantaloupe. So my 602 foundation, y'all with me, only exists through hearsay. So then we have a problem. Let's say a team objects to lack of foundation. And then the response is, well, he knows about Lily stealing the cantaloupe because someone told him. Then the other side might say, well, in that case, Your Honor, I would amend my objection to hearsay. The only way this witness can know whether or not Lily or Leo Piazza stole the cantaloupe is through the hearsay account of someone else, an out-of-court statement offered for the truth of the matter, and therefore it's also an admissible hearsay. Okay, so that's how a lot of times 602 can very quickly morph into hearsay. And so this often happens with cops, and that's been the struggle. I don't know why I did that. Often happens with cops. And oftentimes, like fun facts, for your edification, that's been the struggle historically with AMTA cases, because a lot of the time, like last year's case with Nichols, there was a police officer named Nichols, and most of his affidavit, well, not last year, it was 2 years ago, I guess, my senior year. Jesus, time flies. Anyhow, a lot of times, that cop, half of his report was hearsay because it was him writing down the information that others told him. So anything he has to offer in terms of knowledge is based on the out-of-court accounts of other people. And so because it's technically hearsay, you have to find another basis, which is to say that 602 and 801, and this is really technical evidence that you would read in an evidence textbook that I'm going to, kind of splash at you now. .602 and 601, or excuse me, 602 and 801 incentivize eyewitness testimony. They put a priority on getting people who were there to see it and observe it to the stand because they're more reliable, quote unquote, than those who just hear about it through the streets, through the gossip. Okay? And so that's sort of the incentive structure that is created because of the rules, and that's something that happens through this chain. Y'all see that? That's all I'm going to say on that for right now because we got to move on. But this is I put this on here and took the time to make this aside because it will come up. I don't know how yet, to be real with you, but I'm sure it will. Okay, so be prepared. Oh, when you're writing directs, make sure that we're relatively clear to avoid putting ourselves into this chain. Or at the very least, if it's unavoidable, find a non-hearsay argument. I'll just put /except. Find a non-hearsay /exception argument. Okay? Let's talk about 701. Y'all know what 701 is? Hopefully I have a picture of it, because if not, it's going to come right off the top of the dome. Like Kendrick Lamar on Sway in the Morning. Let's see. That reference probably went over all of y'all's heads, but that's fine. Alright, yeah, it's coming off the top of the dome. So 701, as you all know, I made a mistake. 701, as you all know, Lord have it, is opinion of a lay witness. Okay? So a lay witness is very fancily defined as non-expert. In other words, Any witness that you can't, for whom you cannot establish 702 foundation, okay, is therefore a lay witness. And lay witnesses are limited to two things. One, their observations. And observations here, what I saw, touched, all of that stuff, felt, see, touch, feel, all that stuff, heard. So those senses that you hear about in grade school. Okay? So your five senses. And then the second thing they can do under 701 is testify to their rationally based perception. Now, my little brother, God bless his heart, he always had the hardest head, and he still does. And he used to roll his eyes when I would tell him that there's a difference between these two things. But surely as my middle name is Anthony, I assure you that there is a difference. And I'm going to give you an example. You ready? Lift your hands to receive it. Let's use somebody different so Lily is not singled out. Lillian saw Alexis leave. That's an observation, okay? She saw it directly, okay? Lillian heard the door close and noticed Alexis was gone. Semicolon. She concludes Alexis left. That is a rationally based perception. What's the difference here? This is an inference. Okay? Well, logically speaking, very technically, it's a hypothesis. But whatever. No one asked me for my BS degree and my opinion on crap. Okay? But anyway, it's an inference. Okay? She has drawn a conclusion based on her observations. If she's allowed to do that insofar as it's rationally based. Now, rationally based, what does that mean? Remember, they're still bound by this. They're not experts. So they can't come to an inference that would require specialized knowledge, but they can use reason, however you want to define that, in the Kantian extrinsic way or in the economic instrumental way or whatever, however you want to define reason. You're allowed to use that to make your inference, but you can't use or utilize specialized knowledge in coming to that inference or that conclusion if you're not an expert. So you're bound by the fact that you're not an expert, but you can still draw conclusions based on a set of simple facts. Here's a simple fact. You don't need to be an expert to know that the door was closed or that you heard the door closed. You don't have to be an expert to hear it close, and you don't have to be an expert to notice that Alexis was gone. So you can make a very reasonable conclusion that Alexis had left. It doesn't require specialized knowledge. As long as the inference does not require specialized knowledge, again, you're bound by this. Y'all see that? Y'all see that arrow? You're bound by that. But you can still make an inference and come to your own conclusion. Okay, so that's the difference between just sheer observation. This is what I saw. This is what I heard. Okay, this is what I touched, whatever. Versus here's my inference based on that. And it can't be, drawing your own. It can't be someone just opining. It can't be someone editorializing. It has to be a reasonable inference, relatively deductible, for lack of a better reason, or it's not deductible, probably deducible. I don't know. Let me look it up. I'm out here making up words like I'm George Bush. Let me see. I think it's just deducible. Let's see. Or, let's see. Dictionary.com. Let's see. No, it's deductible. There we go. It's deductible. But anyway, it has to be a, nope, okay. It has to be a conclusion relatively deductible from what they've observed. It can't just be I editorialized that Leo did it because it was cold outside. It has to be, here are the facts that I observed and this is my conclusion based on that. That doesn't require specialized knowledge. I'm out here making up words. This is going to bother me now that this is on tape. I sound like a complete knucklehead. Jesus of Nazareth. Y'all pray for me. Y'all not praying hard enough. Anyway, well, I'm gonna have a crisis about this. So let's continue. Let's go to 702. 702. Y'all ready? Put your roller skates on. 702 should be quick, fast, and in a hurry. Because you ought to know all the prongs by now. But I gotta introduce some case law. Then we're gonna go through 703 through 705. If you with me, say yeah. Yeah, 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 yeah. Oh, yeah. If you with me, tell the Lord yes. Oh, yeah. I hope you're with me. Alrighty. 702. I feel good. 702, children. 4 prongs. This is obviously the expert opinion rule. Okay? Hopefully I don't have to. Again, y'all have heard of these things before, but we haven't actually sat down and, systematically gone through these things with you. Hopefully this video does that. Okay? So, 4 prongs to 702. Specialized knowledge. Y'all see that? Abbreviated as CAN here. B. Sufficient facts. C. Reliable principles. D. Application. Simple and plain, right? You have to have specialized knowledge. Now, a brief word about what constitutes specialized knowledge. So, specialized knowledge does not necessarily mean education. Most of the time, 9 times out of 10 in the mock trial context, it will mean education. Uh, most of the time, it will mean education. But sometimes it could just simply be uh, experience, as you can see here. Sometimes it could be training. So, in other words, I didn't get my degree in horological studies, but after having spent a year and some change working on watches and having been trained from everything that's to, putting in or taking out a battery to deconstructing movements to taking off and putting back on hands and resetting stems and screwing on crowns and taking out crystals and putting on bands and taking out links. And as you can see, it's a lot more straightforward or a lot more intricate than what even the layperson would imagine. One might try to tender me as a watch as a expert in watches based on my training and my experience, even though I don't have a formal degree. Okay, so all of that, your expertise, your not expertise, your experience, your training, your education, your knowledge or skill may constitute your specialized knowledge. Okay, you have to have it. Okay, so I just made a boo boo. Now, sufficient facts and data. So, a word about that. Sufficient facts or data. I'm going to say a word about B through D, actually, because this what I'm about to say is applicable to all these points. Y'all ready? Put your roller skates on. Write this down, because it's going to come up. Wink, wink. Nod, nod. Wait a minute. A rules assessment's coming up. I wonder if those two things, what I just said about something coming up and this rule assessment, ain't that something? I'm gonna chew on that. I'm gonna let that marinate. You'll probably catch it on the way home. Anyway, write this down. Counsel does not determine this. What do I mean by that? A lot of times you'll get an objection to one of these three prongs, whether the testimony is based on sufficient facts and data, whether or not the testimony has a reliable method, or whether or not the method has been reliably applied. Okay, a lot of times counsel will say it hasn't been. Why do I know it? And they'll give you reasons why it hasn't been. All that's necessary under 702 is that the witness establishes this. I can't even spell establish. Lord have mercy on me. It's the last and evil days. Jesus of Nazareth. Something wrong with me, y'all. The witness establishes this foundation. Okay? This ain't, the counsel cannot just give his reasons for why he doesn't personally believe B through D have been met. The witness has to establish. So in other words, as long as the witness says, I have sufficient facts to reach my conclusion, or I applied this method and here's how. As long as the witness says that, you're fine. Okay? Reasons why counsel doesn't trust the application. Reasons why, this ought to sound familiar if you watched the last video on them chains. See how it all comes together, children? Because I'm getting ready to say it. Reasons why, let me write it down for you. Reasons why why the method wasn't applied uh, as rigorously, or whether or not the facts were truly sufficient. Were truly sufficient. Things that opposing counsel might say in opposition to uh, an expert, whether or not the facts were truly sufficient. I'll put truly here. They go to what? Come on, y'all. Y'all better be saying it with me. I hope you said it with me. It's like Dora the Explorer. They go to wait. Here it comes. Y'all ready? Don't get mad. Get glad. Look at that. Bam. Y'all see that? Look at his big old belly. Here come his belt. Here come his cuff. Bam. Reasons why the method wasn't as rigorously applied. And the reason why I put rigorously in quotations is because these are the buzz phrases you ought to be listening to. A lot of times, people who oppose experts will say things like, "Oh, this method, you know, here are several reasons why this method might not be effective. It doesn't take into account this or this or this. Uh, it doesn't take into account all the factors. So I guess if someone's crossing a Quincy or something, and the opposing counsel says this method doesn't take into account rigor mortis, that goes to weight. Someone might say, well, the fact that Quincy didn't factor in body temperature as a factor for the enthalpy, the rate of heat loss. So therefore, the facts that Quincy relied on, weren't sufficient. That goes to weight. And remember, questions about, the reasonableness, the credibility of the opinion do not make it inadmissible. Okay? Remember that? Let me write that down for you. Because this is important. This is what makes experts difficult in a lot of people's eyes. I don't think they're that hard once you get the hang of it. But this is what makes them difficult. Reasons that affect and opinions, can y'all hear me? Opinions, credibility, aren't automatically, I guess I should say, defeasible arguments. And by defeasible, I mean arguments that defeat or poke holes in, or, well, no, that's too weak of a word here. I don't mean defeasible. I guess I should say aren't necessarily or aren't automatically, I'll say exclusionary. Meaning they don't just because, let's go back to the Quincy example. Quincy, for instance, doesn't take into account body weight and the effects on body weight of the rate of heat loss. Just because it doesn't take into consideration that factor, it doesn't make it, therefore, an inadmissible opinion. It just goes to the opinion's credibility. It goes to weight. Because remember, whenever you're thinking about whether or not an argument goes to weight, you need to think, what is the bar? In the context of 702, it's specialized knowledge, sufficient facts and data, reliable principles and methods, and reliable application. Okay? And those things are all established by the witness. Okay? Insofar as you have a very particular argument for why the opinion isn't credible, for why the opinion isn't as sound or as persuasive or as conclusive as the proponent or the person calling the expert would like to make it seem, that doesn't mean it's excluded. It just means it goes to weight. Okay? So remember, the first thing you need to think of is, does it go to weight? In other words, does your argument solely talk about the credibility or the reasons why the evidence shouldn't be considered as strongly or should be reconsidered, considered in a different context, considered in a different way? Those arguments go to weight, and then, that's what we should be thinking. Whenever we have an objection, we should always think, does the argument go to weight? Okay? Y'all with me? I hope so. I gotta find that song. Take it back, rewind it back, because this is gonna be pivotal for us to understand, because it's gonna come up throughout the year. Okay? Few more things. I know I told you that this video was going to be short. Once again, I lied. Whenever I say this video is going to be short, y'all should just ignore it. Like, honestly, if you're still taking my word for that at this point, I mean, it's on you, okay? So do we get this weight thing? Does it go to weight? If it goes to weight, then it doesn't automatically, the argument doesn't exclude the evidence. It's not an argument to squash or suppress or strike the evidence, okay? If it goes to admissibility, then it's directly contesting whether or not foundation has been laid. I wrote, again, y'all let me just write these stupid things that make no sense and don't say anything. Okay. An argument to admissibility goes to whether or not the proper required foundation, the evidence supporting an argument, the argument that this person has expertise, it can reach an expert conclusion. If an argument goes to admissibility, it goes to whether or not the proper foundation has been laid. And it's foundation that the witness must lay. The attorney simply can't assert that they didn't have sufficient facts. His reasons for why they had insufficient facts go to weight. Insofar as the witness says they have sufficient facts, they have sufficient facts. Insofar as they have a reliable principle, let's talk about that. They most likely have a reliable principle. But there is a case in real life, and there's a case in the AMTA case file that talks about it. Let's talk about methods. Okay. Tarot readers. Freshmen, get this case in your head, because it will be in every case packet from now to the end of time, because it's based on a real case called the Daubert standard. Okay? So Tarot Readers v. Merrill Dow. Okay? This case establishes factors. That's a key word. It's a factor test. A factor test is non-dispositive, meaning the case lists out a list of reasons or a list of things to consider that don't necessarily have to be established. Okay? For a reliable method. Okay, so in other words, this case goes specifically to 702C. You with me? You with me? Okay, so Tarot Readers Association of Midlands v. Merrill Dow is a case talking about the reliability of methods. It gives you a factor test. I think it's 4 factors that can be considered in deciding whether or not a method is reliable. Again, with me writing nonsense, non-dispositive. Okay? The factor test is non-dispositive, meaning that if you don't have the factor, it's all right. Look at your neighbor, say it's all right. You can have one of the factors, you can have all of the factors, you can have none of the factors. Non-dispositive. One does not have to establish them in order for the method to be found reliable. But they are a helpful guide. They're persuasive, but they're not conclusive. Okay? So one of the factors is whether or not the method is widespread in the field. So widespread use has a known, not a non-error rate, Nimrod, a known error rate, whether, I just blanked, no error rate, whether it's peer reviewed, those sorts of things. And there's one more factor that I really don't feel like looking up. I always forget this one. But the point of the matter is there are these 3 factors here. 4. Let me see. I'll find it, y'all. You know I can't leave y'all hanging like that. I'm sorry. I feel bad even trying to leave y'all hanging like that. I can find it real quick. I always forget this 4th one though. Do 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 do. Do 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 do. Here it is, the 4th factor. No error rate, widespread use, peer review, whether it has been tested, so testability. So is the method just simply, I looked at a document and I read it and I came to a conclusion, or is the method an experiment in the way that a chemist would conduct an experiment? That's a factor. So these 4 factors are non-dispositive, meaning that they don't have to have them, but they're helpful, okay, in helping the judge determine whether or not a method is reliable. One does not have to have them in order for the method to be considered reliable, but it's helpful, it's persuasive. And these reasons often are these factors, the absence of these factors, the abundance of these factors, they go to weight. They don't even go to admissibility by the very wording and construction of the case. Okay, they go to weight. So there you have it. All right. I hope that's clear, because we're moving on. If it's not clear, take the track and rewind it back. Okay. So let's speed. Well, not speed too fast. Let's go to Rule 703. I hope it's up here. I hope I have a picture of it. I think I do. Probably not. Lord. Well, whatever. Here. Let's do it. So, nope. Okay. It's going to keep fighting me. Oh, now it wants to pull up. Well, now it's trying to open something. Let me see. Let's try to find it. Sorry, y'all. You'll be alright. This is why you tune into the videos. What new ways can Jabari screw up technology? I don't have that picture. Okay. Well, that was a bunch of wasted time. Okay. Well, listen to me. Otherwise, inadmissible evidence. So experts can rely on, I'm just going to write OIE, otherwise inadmissible evidence, okay, to form their conclusions. Here's the big part. And disclose it to the jury, okay, as long as it survives a, watch this is important, reverse 403. So what's 403? Evidence that's substantially more prejudicial than probative. Well, if it's a reverse 403, then that means that the evidence has to be substantially more probative than it is prejudicial. That makes sense, because this is to prevent 703 or witness or experts from being used as conduits. Okay, and you get this term conduit through Mississippi Barbecue v. Richards, or I think it's the other way around. You have to check in your case packet. Okay, so conduits to hearsay. So that's an example. You can't simply use your expert to backdoor in a bunch of evidence that you know won't normally come in. That would be a really bad faith use of experts, right? Y'all with me? So the protection that this rule affords against that is the reverse 403 test. Okay? I'll say protects from bad faith use. Okay? The reverse 403 says in order for you to disclose the otherwise inadmissible evidence, and remember, that could be anything. It could be hearsay. It could be character evidence. Okay? It could be any otherwise inadmissible evidence. Okay? To form their conclusion. If they can rely on it and disclose it, as long as the probative value of disclosing this evidence insofar as it helps their conclusion. So in other words, the probative value of evidence to help the jury understand the conclusion. Okay? It can't just be, oh, here's a bunch of hearsay statements that I wouldn't be able to get in through another witness. Let me try to throw it in right now with Washington as an expert or with Quincy. No. The evidence that's otherwise inadmissible can be disclosed to the jury as long as the evidence's ability to help you understand the conclusion substantially outweighs the unfair prejudice. Okay? And you can't simply be a conduit to hearsay. What's that? You can't use witnesses to simply document dump. This will happen all the time on cross. And I'll discuss with you later what's called the Richmond rule. I'm not going to discuss it now because I don't want to go down a rabbit hole and I want to keep moving. But, ask Supreme Court Justice Madam Magna Melcote what the Richmond rule is. She probably still won't know, but I used to write it in my notes to her all the time. The Richmond rule is simply not allowing people to cross our experts with documents that they quote unquote relied on just to get out quotes that are helpful to their overall case theory. Why is that wrong? Because you're using them as conduits. You're using them as a pass through to get in hearsay without actually taking the time to make them apply their specialized knowledge. Okay? I know this board is everywhere. But you have to apply your specialized knowledge to I'll put here to the OIE, to the otherwise inadmissible evidence. You can't just simply, spout it. You have to apply the specialized knowledge to the otherwise inadmissible evidence to help the people, help the jury understand how that evidence informs your particular conclusion. And a lot of time, bad teams will do it. Listen to me. They're going to try to use our expert to. I don't know how you could really do it in this case, but in past cases, teams would do it. When experts would rely on like 5 people's affidavits. The fun thing to do with them would be to try to, pick out quotes and observations from the affidavits and then elicit them through the expert witness without having them, tether it back to their conclusion. No. Whenever an expert on direct or on cross elicits out of court statements or otherwise inadmissible evidence, they have to apply their specialized knowledge. Do y'all see that? I'm going to draw a nice little fountain. There is a fountain filled with blood drawn from Emmanuel's veins. Y'all see that? Whenever they use otherwise inadmissible evidence, they have to apply their specialized knowledge. They can't just be conduits. You can't just get the expert up there to, spout out quotes. Okay? You have to apply specialized knowledge to the quotes to help the jury understand how those quotes played a role in their conclusion. Alright? Look at your neighbor, say he almost finished. I'm going to do these 2 rules in 5 minutes. Promise you. Because these are simple. Witnesses. Well, I wrote 704 twice. See, y'all not praying with me. Y'all must. See here. 705. Okay, 704. An opinion is not objectionable because it embraces the ultimate issue. Y'all see that? Well, that's what I get. Because that looks like a V. okay, is not objectionable because it embraces the ultimate issue. Okay? So, in other words, in high school, apparently the popular objection was to object to ultimate issue. That's Sam. That's Sam's favorite rule. No, Sam Yeager. No, that is not objectionable in college mock trial. An opinion could embrace the ultimate issue as long as it doesn't, uh, as long as someone doesn't opine to whether or not the defendant had a necessary mental state, which is which constitutes a element of the crime. So the B part of the rule, I don't know what I'm writing here. And this mental element is kind of a crim law principle we call mens rea. Okay, so as long as the opinion on the ultimate issue doesn't embrace the mens rea component, so and that is the mental state as an element of crime. So in other words, in this case, we have an aggravated murder case. If somebody Quincy couldn't say Jordan Ryder intended to push the little girl's name. What's her name? Uh, Parker something. Anyway, the the Jordan Ryder couldn't. He can't say that Jordan Ryder intended to push the little girl off the cliff. Can't say it. Why? Because that opinion would be embracing or testifying to whether or not the defendant had the necessary mental state, had the mens rea, okay, to commit the crime. That is a fact, or that is an issue that is only that can only be decided by the triers of fact, the jury, members of the jury. So whether or not someone had the mental state is an issue for only the trier of fact. It's not for a witness to pontificate on. So as long as the expert doesn't, opine on whether or not the defendant had the necessary mental state, intent would be one of those, or knowingly, whether or not someone had the knowledge to do something. In the involuntary manslaughter case, it would be an opinion on whether or not Jordan Ryder had knowledge. As long as someone doesn't go into that, they can have an opinion that embraces the ultimate issue. Okay, i.e., whether or not Jordan caused the little girl's death, whatever her name is. Okay, last one. Underlying facts and data. An expert witness don't have to disclose the underlying facts and data unless they're ordered to by the judge. Or expert. Let me erase that because that looks deplorable. The expert is, I wrote is twice, crossed on it. Okay? Y'all see that? Look at your neighbor saying, I see it. Now, this rule is just explanatory. Experts technically don't have to disclose their underlying facts and data. They only have to testify that, again, let's go back to the 702 bar, that the facts and data were sufficient. But they don't have to testify about what they were or how they factored into the conclusion. They only have to testify that they had sufficient facts and data. And they technically aren't bound to disclose the underlying facts and data unless the judge wants them to. Okay? Or unless they're crossed on it, because they can't just go mute on cross if the crossing attorney starts asking them about it. And that makes sense, right? So that's a simple rule, okay? But just know it. All right? So that concludes the rule lecture. This will be the last rule lecture for 2019. I promise you that much, because as good as I am at acting, I promise you, these videos are hard to make. The technology is really intensive. And, I'm not very good at it. But I do enjoy teaching. And I hope that you all have gotten something out of these videos. Remember, I love you. And God loves you, so do I. And I'm going to see y'all on Monday for this rules assessment. So, how do I say goodbye? I don't know, y'all. You tell me. But until Monday, y'all, remember that the love of God and the grace of the Lord Jesus Christ and the sweet communion of the Holy Spirit rest, rule, and abide henceforth and forevermore. You may go in peace. Bye-bye.